I now call to order the December 13, 2023 Zoning Board of Adjustment meeting. We have item 1, public hearing. Citizens who desire to address the city council and a board and commissions and with regard to matters on the agenda must complete a request to speak form and give it to the city secretary or designee prior to the beginning of the meeting. Each speaker is limited to 3 minutes. Speakers requiring a translator will have 6 minutes, regardless of the number of agenda items to be addressed. Comments or discussion by the city council board and or commission members will only be made at the time the subject is scheduled for consideration. Do we have anyone sign up?
No, sir.
Okay. We go to item 3, minutes, consideration of an action on the minutes of the November 15th, 2023 meeting. Do I have any comments or a motion?
Motion to accept.
I have a motion to accept the minutes. I have a second. Second for Mr. James. We vote by hand. All those who in favor say, raise your hand. Okay, motion passes unanimously. Item 4, orientation, review of and discussion on purpose, roles, responsibilities, and functions of the Zoning Board of Adjustment.
All right. Good evening, Zoning Board of Adjustment members. How are you this evening?
Good.
Glad y'all are here. So to fulfill your annual requirement for an orientation, we are going to do that tonight, but we've also got an added guest. Our city attorney will be covering your ethics training, which is also an annual requirement. So we'll go through that. But just wanted to briefly talk a little bit about the department. We are, and Lauren will probably go into this a little bit more detail, but the Planning Development Services Department is essentially your support for the board from a technical aspect, preparing the items, working with the applicants for the cases that come before you. We have 2 primary divisions within the department. We have our Development Planning and Development Services group, which Lauren heads up as the assistant director. We also have building inspections and plan review, which is led by our chief building official, Joshua Doyle. So this staff within these divisions work hand in hand through the permitting process, through the development review process, and ultimately some cases come before you for your approval as well. Just want to quickly list, you all know that you are on the Zoning Board of Adjustment, but just want to really take the opportunity to thank you for your service. I know this is, we've had actually a lot of meetings this year. I know there's been some years where it's been kind of quiet, but we've had a good number this year. And really just thank you for your service. I know the applicants that do come forward appreciate your due diligence and your expediency that you move through the cases, because they are projects, they're your neighbors. In most cases, people that live here in the community that are anxious to do projects, and really what stands between them and that project being completed is this approval from this board. So really thank you for your service to the community, whether it's been for several years on this board or if this is your first year. Hope you've had fun and you find it fulfilling. So thank you. I'm going to turn it over now to Lauren, and she's going to walk you through several aspects of the cases that come before you.
Yes, thanks. I do have a number of slides, so I will try to be cognizant of everyone's time. It won't take 2 hours. So the board authority comes from a few places, primarily from the Texas Local Government Code in Chapter 211. So that authorizes a number of elements as they relate to zoning, one of them being having a zoning board of adjustment. So you're charged with hearing and deciding on relief from zoning regulations. The city charter also establishes the board and follows the Chapter 211 in terms of number of members and what you hear in your cases. Development code, and then you have the adopted rules of procedure. So under the state legislature, a zoning board of adjustment does need to have adopted rules of procedure. We operate under those. Talks about swearing in the speakers, attendance, the meeting times, setting them as the 3rd Wednesday of month, what the quorum has to have 4 members. Those things are in our rules of procedure. Just mentioned that, attendance for the meeting. The board is composed of 5 with alternates. Quorum is 4. Expectations just kind of laid out through the rules of procedure that all regular members and alternates will make the meetings, notify us when unable, and that alternates will sit and attend the meeting just so they can fill in if needed, but also allows for familiarization with issues and decision-making on our different types of cases. So our staff role. So we're the liaison to you all, to the board. We review and analyze the cases that are going to come before the board. All of them have mostly come through the primarily ones you see through a building permit process. So we've reviewed that. We've coordinated with other city staff, engineering on the building permit, our building department, and prepare the case material, including public hearing prep work, and then providing the information such as written agenda requests and the PowerPoint to the board. So I'm going to go through the 4 main types of ZBA cases. Variances, well, 3 of them we really don't see a lot here. Variances, appeals, and then the very, very infrequent role as the Airport Zoning Board of Adjustment, but as well as special exceptions, which are related to setbacks, and that's primarily what you all see on the board. Variances, the Texas statute allows variances as a zoning tool for zoning relief when there are special circumstances. It does not allow for land use variances, but since they are pretty infrequent, the staff, we would brief you all on the specifics of each of their criteria. If a variance were to come forward, we would step through that pretty detailed with you all because they're infrequent. And we do not provide a recommendation on variances as you see in the special exception cases. So variances, these are the criteria, and they're not contrary to the public interest. There are special circumstances or conditions of the land that literal enforcement of the ordinance would result in a hardship, and that the spirit of the ordinance is observed. So I'll step through these fairly quickly. So criterion 1, and again, we would assist with these criterion if a variance was coming forward, but not contrary to the public interest, taking into context the case, any public comments or concerns. Criterion 2, if there's any circumstances that might apply to the land or to the building, and we would analyze that and kind of point to some of those potential conditions that might be unique lot sizes, a tree in the middle of the lot, location of existing structures, and taking a look at that. And then criterion 3 looks at what is reasonable as to necessary or unnecessary, and if the literal enforcement would result in a hardship. We did receive new state law and a House bill the last session, actually the session before last in 2021, clarifying what a hardship is and added a financial component to what could be considered a hardship. So it now includes a percentage of value for if your financial cost is greater than that, if you had to comply with the ordinance. So this is all about if you had to comply, what would be your hardship. If you lost a percentage of your lot area where you could develop, if you complied, complying with another code would cause loss of compliance. So it's all about verifying and proving that the hardship. And then criterion 4, it's the spirit of the ordinance, and this would be, the board weighing in on if the intent of the ordinance was there with the special conditions that were present in the case. You can have conditions, screening, buffering, extra landscaping, some other kind of elements, and then you would look at compliance with kind of what we typically see in special exceptions. Your site plan, your elevations that are related to the case. So special exception, this is the one you see more often. So again, the statute allows for special exceptions as a tool for zoning release. They replaced our variance process, I think 2007, for residences that were platted prior to being annexed. So that's the criterion for being qualifying for a special exception. So it allows the property to comply with your recorded setbacks, your deed restrictions, your platted restrictions, instead of the current zoning setbacks. And these are the criterion we go through at every meeting. Are they platted prior to annexation? Recorded restrictions are less restrictive than the zoning. The special exception would not be less restrictive than the recorded restrictions, and the compatibility to the neighborhood. The first 3 criterion that you see there with the check marks, we verify those prior to even accepting the special exception application, so you wouldn't see anything come before you that didn't meet those first 3 criterion. And then criterion 4 is one that you all would decide as far as the case analysis. So this is just an example. This is actually one of your recent cases. I think we saw a couple months ago in the fall. So you have the recorded plat with the platted restrictions, but then, we took a look at the setback requirements where it can be 5 feet from the property line, and that is what we took a look at in that case. Criterion 4, the reports would provide information on looking at the surrounding neighborhood and the existing conditions. I think I have a slide on that. Yes. So this is kind of what you see in your report. So looking at materials and what the rest of the neighborhood looks like, how many other cases have been approved in the neighborhood, and then taking a look at that aerial as to other setbacks that might be less than what the zoning restriction is. And again, these are just taking a look at the criterion, but this goes through the decision options that you have as the board. So approval, that it meets all the criterion; denial, it's not compatible with the existing neighborhood; or approval with conditions. Those are the 3 options of being able to vote on an item. And we would provide a recommendation to you all as well. So they can have possible conditions. It could be approval of a setback that's between what is requested versus the regulation. 15 is required per the zoning. Maybe the 10-foot is the platted setback, but we grant 7. So including the site plan and the building elevation drawings is typical, and those are what get approved with the special exception. And this is an example of the same plat I showed you earlier. This is the specific site layout plan that the board would approve. So showing the existing structure, the patio cover extending into that 15-foot setback that's required per the zoning, but being within those parameters of the platted, I think it was a utility easement in this case. Okay, so appeals. This is the 3rd type of case that you all don't hear often as well, but this is an option for determining whether city staff and administration has interpreted the regulations correctly. So we would go through the process. Obviously, we would brief you all before bringing one of these forward since you don't see them often, but the process typically requires an applicant to state what code interpretation they believe was incorrect, providing some burden of proof with that, and then again, it would take a quorum 4 out of 5 vote to overturn the staff's interpretation. You would likely potentially not see us recommend an approval on that because it would set precedence that if the staff's interpretation was overturned, then that board decision would become the rule in the part of the code. And then this is the final role that's very infrequent, if ever, but it's the Airport Zoning Board of Adjustment. So this is outlined in our development code, kind of establishing the regulations, and you all would serve in the role of the Airport Zoning Board if a height variance application is filed. This has to go through the FAA, and there would be, again, we would brief you all, and should a request be filed, we would go through a detailed orientation with you all on that. Okay, and I'm going to pass it off to Meredith for some legal considerations. You sure?
On the zoning request for setback, things of this nature, in structures that are built, patio cover, we've done several of those.
Yep.
Do HOAs get involved?
Yes, so that's part of the process we go through on the front end before we even bring the special exception forward. That part of our building permit process is that if you have an HOA, you need to go through them, and they have to get kind of a letter that they've submitted to them and that they've gone through the process of the HOA reviewing their application as well.
As you're presenting that to the board, could you mention that the HOA has been advised of this or something to that effect? Because we never hear that unless asked.
Oh, okay. Yes, we can include that part.
Because some of the HOAs are pretty militant.
Sure. Sure. Yes. But yeah, ultimately, here in the city, we don't regulate the HOA restrictions. You essentially have to comply with both. So that's why we request when you submit a permit here that you've let us know that you've worked with the HOA so that we're all kind of working together.
So just to clarification, is
Sure.
that a requirement or a request? Like,
So-
do they have to show that the HOA is okay with this before they can submit it to us for approval?
We typically will have them tell us that. I mean, we're not going to bring something forward necessarily that's going to be controversial and have an HOA not approve it. But again, we don't enforce the HOA restrictions. Folks in this residential and commercial have to comply with both the city and the HOA or POA restrictions. So we won't enforce them, but since they are a part of the considerations that you all have as far as a recorded deed restriction, we do, they do need to go through their HOA to make sure that they're in compliance with their deed restrictions. Yeah. Okay.
All right, legal considerations. And I'm filling in for Shay, so this is going to be exciting because I'm going to see the slides right when you see them. Open Meetings Act. Okay, I know this one. The purpose of the Open Meetings Act is to require the government decision-making process to be open to the public. So as you see in front of you, I have an agenda. The agenda says the date, time, and location of the meeting, and then it has the different sections that tell you what you're going to do. So if it's on the agenda, congratulations, you can talk about it. If it's not on the agenda, just sit there quietly, look over the city secretary, or look over to your assigned attorney. Because if you talk about something that's not on the agenda, that's a criminal violation. You also have to post the agenda 72 hours in advance, but lucky for you, TA here is a rock star, and they do that for you. You won't go to jail for that. And here's everything I just told you. Okay, and if you didn't know what a meeting was, I'll just let you know that's 4 of you sitting together in one location talking about what you have jurisdiction over, the appeals, a variance, or a special exception. And if you talk about those and talk about how you're going to vote, you better make sure you're sitting in a location that's been posted on this agenda at the right time and the right location. Okay, there is an exception that if you're, for some reason, you're getting sued or something, or you have a question related to the item on the agenda, you wave your hand. The city attorney, who is sitting here helping you for that evening, will be happy to take you into the council dining room and share all kinds of secrets with you. Whatever happens back there in executive session is attorney-client privilege, so you cannot share that. But you can't take a vote in there. You must come out here and vote. Walking quorum. Oh, this is fun. So a lot of you may know about social media, emails. If you reply all, that's a quorum because there's 4 or more of you. If you post on social media and you like something, you better be very careful and check the people who liked before you, because if 4 of you like the same thing, or one person posts and 3 more people like it, congratulations, that's a walking quorum. The Attorney General's been kind of hit or miss on this. He's gone after a couple places close to the Woodlands, and they've had a lot of fun, a lot of lawsuits, and they've paid a few fines. It doesn't really look too good on your resume, but just be out there and be aware it's not really good to be friends with your coworkers or your co-board members. Not a meeting. Oh, yes, sir.
When we get the meeting agendas and we're looking at the cases, if we have a question about it back to staff, we should just reply to the original email, just reply to the staff members. We don't include any of the board members in our questions or anything like that. We just send it to staff. Right, that's the
Gold
only
star.
correspondence.
That is exactly right. Gold star, yes.
Okay.
We try very hard to make sure that when we send things out to the entire group, we blind copy everybody.
Right.
So that you cannot accidentally hit reply all.
Yeah,
But if you want to go in there and type everybody else in, it's on you, not us. You go to jail, we don't.
yeah.
But we certainly do everything we can to keep you out of
Right,
jail.
okay, so that's,
Quit laughing at me.
thank you.
So not a meeting, social events. It's the holiday time of year. You might be invited to a Thanksgiving get-together. Hey, my kid's doing the Nutcracker or whatever, or we're reading the Christmas book. If you go to that and you're not doing anything related to this board, it's a social event. You don't have to have an agenda. You don't even have to tell us about it. We just want you to have a good time, enjoy your community. Don't tell us. And if you decide not to do this, it's a criminal penalty. It's $100 to $500 fine, 1 to 6 months in county jail, and just depending on how bad a mood the district attorney's in, you could have both. So the best practice is don't talk about this business outside this room, outside a posted agenda. Don't email each other. Don't post on Facebook unless you're willing to risk a violation. Avoid a quorum. Don't hang out with each other. Pick other friends. and stick to the subject matter on the agenda. Oh, that was easy. Do you have any questions?
So if I like Robert's pictures from Europe on his vacation, that's okay.
That's perfectly fine, but if Robert puts on his Facebook or his Instagram, hey, did you like that setback, that patio? Can you believe we did that? Run. Close out your browser. Don't even get involved. Okay, this is the stuff I do know. Ethics. This is my favorite thing, and I could probably do this in an hour and a half, so let me talk fast. So you're here this evening because you're required to do it by the Code of
I'm
Ordinances.
sorry, Meredith, can we do the caption?
I'm sorry. I'm so excited. I got ahead of myself. Go ahead.
Regulating ethics and reporting responsibilities of city officials.
Okay, great. Thank you. This is my favorite thing. I get so excited. So you're here because you are required to do it by our code, and you're here because the council wants to make sure I have something fun to do. So this evening, we're going to play Cards Against Ethics. We have two objectives when we play this game. You're going to receive an overview of the Code of Conduct, and as Lisa said, and as I like to tell you, you're going to get that little checkbox next to your name, and you don't have to listen to me for a whole nother year, unless you want to, because I do this for every board. You can either watch it online or come in person. It's not going to hurt my feelings. So who gets to play our game this evening? Members of City Council get to play, members of administrative and advisory boards, such as yourself, former City Council administrative advisory board members, and every once in a while, we invite candidates for City Council to play as well. I'm going to go over all the rules. They may not necessarily apply to you, but I don't know if you have aspirations to sit on another board or maybe even run for council, so you're going to get a little preview of their rules and regulations tonight, or if you happen to be sitting at home going, you know what? So-and-so on this board did something, I don't know if it's right. I'm giving you the resources to find out whether or not it's right and what actions you can take about them. So we have 8 basic rules. We're going to go over all 8 of those. So special conflict of interest, special economic benefit. We have 2 rules to keep in mind. The rule of 10 and 15, whether you, your spouse, your children, or your parents own 10% or more of the voting stock of a business entity, 10% or more of the fair market value of that business entity, or 15% of your gross income for the last year came from this business entity. What is the rule of 25 for real property? That's $2,500 in the fair market value of that real property. So what happens if you decide that you have 10 or 15% in the business entity or 25% or 2.5 on real property? You get to file a conflicts of disclosure statement with the city secretary's office. You have to abstain and you have to walk out of the room. Why? Because we like the Astros. They throw all kinds of signs. We don't want anybody sitting behind you thinking that you are tipping off your fellow members on how to vote. So an interesting question came up last year as far as real property and whether or not it's a conflict of interest. So if the item on the agenda is your property and you own that percentage, then obviously you have a conflict of interest. What you may or may not know, because I don't attend ZBA anymore, is that we send a notice letter to residents or property owners within 200 feet. If you get that letter, it's because state law thinks you have a special interest in that property. So even though it's not your property on the agenda, if you're within that 200 feet, you get to walk out of the room and you don't have to serve that evening. So relationship with a vendor, you get to brag. And this is one of those things that if you decide to serve on city council, it's very important for you to know. If you receive $2,500 in the past year from that vendor, you get to fill out a form. Or if you're related within the 3rd degree by consanguinity or 2nd degree by infinity, which I don't know off the top of my head, but I have a cheat sheet to my desk if you need it, then you get to disclose that as well. So, and gifts. It is the holiday season. Thanksgiving turkeys are being shared, or they were when I wrote this. So you get to brag about them. So under state law and our code of ordinances, you get to brag about lodging, transportation, entertainment, and food when the cumulative value of those items received from an individual vendor within a rolling 12 months reaches $100. But good news, if you are actually invited to sit there with that vendor and you're close enough to have a conversation and have to listen to their sales speech, you get to order that second glass of whatever your beverage of choice is, dessert, and even a to-go bag. So if you want to tolerate them in person, $500 is your goal. Additional rules: doing business with the city, representations, appearances, misuse and disclosure of official information, participating in procurement, and campaign contributions. So doing business with the city. If you happen to be a city council member during the entire term of your service, you cannot have a substantial contract with the city. What is a substantial contract? It's up to $1,000. Now, the great news about that is if you are a short-term council member, only sit here for 3 years, you get about $332 a year to play with that you can have a contract. However, if you're a long-term council member, go the full 9 years, don't even bother doing the math, just don't enter a contract. It's just too hard to keep up with. Representations and appearances. I don't know if you like to wear hats, but this is a good visual. So representations, if you're in front of another board, you can do only your personal interest. You cannot come in front of this board and represent someone else for money while in front of this board, while serving on this board, or for a year after serving on this board. So you've got all this experience being on ZBA. You go out there, you go, hey, I'm gonna get me some clients, and I'll make some money. That's great, but no, you can't do that for a full year after serving on this board. You're welcome to go in from other boards, don't go in front of this board. Appearances, so as we were mentioning, social media, you may like Nextdoor. When you go on Nextdoor and you talk about things, you need to make sure that, depending on the topic, you tell everybody what hat you're on. So if you say, oh, this is a zoning matter, this is a setback thing, you can say, in my capacity as a ZBA commissioner, I believe blah, blah, blah. Or you can say, as a resident of the city, I believe blah, blah, blah. This is more important for city council members because, as you can imagine, they can never take that hat off. And during certain department conversations, neither can planning and zoning commissioners. So misuse and disclosure of official information. So if you happen to get invited to the back room and have a secret conversation with your lawyer, we ask that you don't use that information for any purposes. Don't tell the other side what's going on, because we are here for you, not for them. Also, if you happen to serve on a different board that does economic development, you get to find out a little bit of secrets about those companies, what they make, you know, kind of what they're going to do, or they're going to buy a certain property. We ask that you don't share that as well, and don't go out and buy the adjacent property, because you now have inside information, and hey, that's a felony. So participation in procurement, this also applies to city council. State law is very determined and set as to how purchases must be made, how it must be bid out, how the notice must be. So if you are in city council, and like I said, I know this doesn't apply to you, but I have no idea what your plans may be come next May. So we ask that if you are interested in participating in procurement, you don't. Because if a council member were to talk to somebody who puts on a bid or a contract that goes for greater than $50,000, we disqualify that vendor. We want to make sure that nobody has special information. All information is funneled through our purchasing department. There's no side deals, no, hey, I'll award this if you give me that kind of thing. And to make it absolutely clear and that there's no gray area, we say don't talk to each other. Campaign contributions. In the unlikely event the city gets sued for greater than $25,000, excluding attorney fees and court costs, you have to return any campaign contribution you get from that person, because you cannot buy a lawsuit from the city. So I went over that very fast. I know you want more information and you're just desperate to read it. So if you get bored tonight, go ahead and go to the Code of Ethics. It's in Chapter 2, Article 4 of the city's Code of Ordinances, which can be found on our website. I went through that fast as well. And if you have questions, you sit at home and you go, you know, I wonder if, you know what, give me a call, shoot me an email. I'm more than happy to answer your questions and give you a written email. Good news about that is it's called a get out of jail free card. So if you come to me and you tell me the facts and I go, well, you know, Josh, you've told me blah, 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 and based on blah, 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 I do not believe it to be a violation of Section 2-175. And you go, okay. And then somebody else comes up and files a complaint. You go, city attorney said I did, it was okay. And then you're not in trouble and the board looks at me. So now, what happens if somebody doesn't follow the rule? A written complaint must be made. I have the privilege of reviewing that complaint, and then the IERB takes over. So, oops, I went way too fast. So a written complaint must be signed and sworn and filed with the city secretary's office within 1 year of the date of the alleged violation of the code, or within 1 year of you finding out of the violation. We want the information and facts to be fresh, and we need it to be a current member, because if it's somebody that, you know, Herbachek or Wallace did in the early 2000s, there's really no impact to us at this kind of day. So if it's signed, sworn, and filed by the city at the city secretary's office within 1 year, it also states who violated it and what the alleged violation is, my work is done. I check the box and I send it off to the Independent Ethics Review Board. That is the entire extent of my involvement, which I absolutely love, and it becomes their problem. So then they're going to look at it, and they're going to say, yes, this person is on a board, this person is an elected official, they are subject to the code. And it's a two-step process. They will determine whether or not there's sufficient information to move forward, and whether the allegations, if true, could be a violation, because they're going to look at it and they're going to go, I just don't think that, skipping across the street is actually a conflict of interest. We're going to send this home. Or they're going to go, oh, yeah, and we want more information. They can only base the first step on the complaint itself, the four corners. So if you want to put anything else in there, it doesn't matter. It has to be on those four corners. If they decide there's enough information on this, they'll go to the second one where they have a full-blown trial and it gets really exciting. So if the board goes to the whole full-blown trial, they can do some sanctions. It starts with a letter of notification all the way down to recommendation of removal. So now you'll notice that number 7 is a recommendation of recall because, as you know, if you're voted in, you can be voted out. We can't just say, have a nice day. So before we play, do you have any questions? All right, let's go. All right. The purpose of the Code of Ethical Conduct is, and this is group participation, please. Oh, you got to read them out. Come on.
Ethical conduct for officials, candidates, and those who do business with the city.
Thank you. The purpose of personal conduct and ethical behavior include
Commitment to the public welfare, fairness.
if you receive a blank valued at over $100 from a city vendor, you must
You got
Candlelit dinner.
We are 100%. Every board likes the can. I have yet to have anybody want a llama.
And then you must file a conflict of interest.
I'm gonna have to do a different one next year. Confidential information obtained during a blank can blank.
Close executive session.
Cannot be used for your own personal benefit.
All right. I just noticed these alternates are not participating. I'd like you to speak up, or you can come. Okay, well, speak up, or otherwise you get to come again, because if I don't hear participation, you get invited to round 2. If you own property within 200 feet from an item on the agenda for consideration, you must blank and blank.
Abstain.
Stay in the room. File a conflict of interest.
I'm watching you. You're being very quiet over there. If you or a relative will receive a financial benefit from an item on an agenda for consideration, you should blank and blank.
File a conflict of interest.
Yeah, file conflict.
Okay. And if you have to abstain from voting on an agenda item, you should blank and then blank.
Leave the room
Leave
while
the
the
room.
matter's being discussed.
And wait outside
I'm
to
so
rejoin
proud
the
of
finish.
y'all.
Rejoin the meeting.
Outside though, right? The dance competition's in the lobby? That's it. Good job. If your friend asks you to use your position on the Zoning Board of Adjustment to blank, you must blank.
To grant approval, decline it.
Because they're,
Grant the approval.
Yeah, grant approval and then
Decline the request, yeah.
okay, so we're going the roller coaster. Got it.
Yeah.
To file an ethics complaint, a blank must be blank.
Signed and sworn and filed with the secretary, city secretary.
Yep. Congratulations, you guys are ethical. I appreciate your time.
Motion to adjourn.
Well done. All right. Do we have a motion to adjourn? Okay, we have a second?
Second.
Raise your hands if you approve. Okay, motion passes unanimously. We're adjourned.
Thank you. Do we get to sign something? Do we get to sign something? That we've done the training?
Is this like a report card to tell my bosses to shut up and
Yeah.
do a good job? I would love that. No, the minutes will show that you're